Good evening, everybody. My name is Jonathan Keller. I'm the President and CEO of California Family Council. It is a pleasure to be with all of you this evening. Thank you for those of you who joined early. If you were particularly on the ball, you actually got to hear a little bit of the behind-the-scenes discussion with Dean and Michael and I. So that is the reward of punctuality. If you show up 10 minutes early, sometimes you can sneak ahead before the event has actually started. So if you missed it, I'm sorry. You'll never know what was said during those special 10 minutes. So I want to just thank you all so much for being with us today. And I am especially grateful for our great lineup of panelists who are going to be sharing with us some vitally important information this evening. And I'd like to, before we actually kick off and before I introduce them or have them introduce themselves, I want to make sure that we begin this with prayer, because I am keenly aware, as I think all the rest of our panelists are, that unless the Lord builds the house, the laborers labor in vain. And that is true not only for this webinar, but it's true for everything that our organization does, and I know our friends in these other organizations feel the same way. So if you'll just join me with a word of prayer. Father God, I just thank you so much, first off, for the blessing it is to be able to be your children. When we think about parental rights, we think about parental authority. I just think of the fact that you are the ultimate loving father, and you have set such a perfect example of what it looks like to care for us, your children, sometimes even when that involves tough love or difficult decisions. You have led by example all throughout all of human history. And I thank you. I know every day when I am trying to parent my own two rambunctious boys, 8-year-old and 5-year-old little boys, there are so many times where I am reminded when I say something to them, I'm kind of pricked at my own conscience of thinking the ways that you are still parenting me and leading me, even as a 43-year-old. So I thank you for the goodness in our lives that you direct us and guide us. I thank you for the fact that you have entrusted so many of us on this call and so many people watching on YouTube and in the future. You've entrusted us with the brilliant opportunity to lead your children. We have an opportunity to love others, to care for others, and to really just steward the resources and the individuals who you have given us. So I pray as we're hearing tonight from Dean and from Michael and from Kate that you would speak through them, give us wisdom so that we know exactly what it is that we should be doing as parents, how we can also share this information with friends and family and fellow church members around our state and even around the nation who want to know how to protect their children, how to guide them and to lead them, and to raise them up in the fear and admonition of the Lord. So we thank you for this opportunity. Bless all of our panelists and bless all the listeners. In Jesus' name we pray. Amen.
Amen.
So we have a wonderful, as I said, a wonderful panel and a wonderful lineup today. And I'm going to go ahead and just introduce kind of on a big picture side of things, the name of the organizations. Because I'll be honest, sometimes I try to introduce people reading bios and things like that, but sometimes it's better just to hear in their own words why some of these individuals are doing what they do. Not just their technical resume or their CV, but I want you to hear from them that these are not just three amazing attorneys, but these are brothers and sisters in Christ who are doing this. I think it's fair to say not for the paycheck. I think all three of them could be making significantly more money if they were working at big law or criminal defense or something else like that. And instead, they are choosing to invest their time, their talent, and their treasure in equipping all of us to, again, as we said in the opening prayer, to care for our children. I can also tell you I'm so grateful these three organizations are not charging any of you anything to be here. They're also not charging us at CFC to be here. So I am just so grateful for their time. I hope that at the end of this, you will go and look up all of these organizations, consider signing up for their mailing lists, maybe making a contribution to their ministries, and maybe make one to CFC as well. But you can spread it around. With that huge tax return that you're going to be getting in the next couple of days, you can invest and pay it forward. So. But with that in mind, I think if it's all right, folks, if you would be willing to maybe just give a very brief introduction to each of you and your organizations to start, and then we can actually jump into the main portion of the webinar, if that's all right. So Kate, if you don't mind, with Alliance Defending Freedom, Kate Anderson, we'd love to hear from you first.
Yes, thank you, Jonathan. So I'm Kate Anderson. I am Senior Counsel with Alliance Defending Freedom, where I direct our Center for Parental Rights, which is our litigation group that's entirely focused on parental rights work. So all day long, me and the 6 attorneys on my team are working on cases to ensure that parents' rights are respected across the country. And Alliance Defending Freedom has dedicated over the last few years to this issue. We historically have done much work on life, on free speech, on religious freedom, really many constitutional issues, but parental rights was a nice dovetail into what our focus is. And so we've really been building out a focus on that to be able to protect parents. And I'm a parent too. My kids range from 6th grade to preschool. And so we're covering some ground over here. So it's vitally important to me personally as well to be here.
Awesome. Thank you so much, Kate. Dean Broyles.
Yes, my name is Dean Broyles. I'm with the National Center for Law and Policy. We're a pro-life, pro-family, pro-religious liberty organization. We do a lot of similar work that Alliance Defending Freedom and PGI do. We're just a lot smaller and not as well funded. But I'm a constitutional attorney and also a father and grandfather of many children and grandchildren and a growing family. My wife also is a public school teacher here in California. And so we've done a lot of work over the past 30 years in the space of LGBTQ issues and marriage and family and school issues with teachers and students and parental rights, a lot of parental rights issues. And glad to be here tonight.
Awesome. Thank you, Dean. And Michael, you are muted, just FYI. So there we go.
Sorry about that. So yes, thank you so much for being here, everybody. And I'm humbled and blessed to be with you all, with these stellar leaders in this thing that we call practicing law for the Constitution. Pacific Justice Institute is a nationwide organization that specializes in religious liberty, parental rights, of course, and pro-life causes. And we're blessed to do that. We're blessed to be able to offer our services without charge. And again, I think we have some great things to talk about, and I thank you so much.
Absolutely. Thank you, Michael. Well, we have a packed webinar, so with that kind of background, I want to make sure that we can jump right into things. And Dean Broyles, first off, I want to say thank you so much for the hard work you've done on helping get all of us herded, all the cats herded and everything organized. And we essentially have kind of 3 big 12-minute sections to start off the webinar. We're going to talk about 2 Supreme Court cases and then 1 really important teacher freedom case, or issue, I should say. And then at the end of that, we're going to make sure we save time for questions and answers. So between now and then, over about the next 30 minutes, you're going to hear in order from Kate and then Dean and Michael. And please use the Q&A box to ask any questions. You can ask them throughout the webinar. We will save those to the end. So make sure, don't think you're going to wait till the end, and just remember, if you think of a question for Kate during the next few minutes or for Dean during his section, don't wait until Michael is halfway done to ask a question. Go ahead and ask it sequentially, and we'll save all those up till the very end. But with that in mind, I think to start off, we want to talk about one of the most important Supreme Court cases in the last, I think, probably 20 years, if not longer, and that is the Mahmoud v. Taylor case, dealing with the rights of religious parents to opt out of certain curriculum and certain classroom activities. So, Kate from ADF, please take.
Well, I'm excited to get to go first and talk to you about this incredible case, because this has been a huge change in the law. As Jonathan said, it really stands for the principle that parents direct their kids' upbringing in the public schools, and that they have the right to get notice and an opt-out of curriculum that violates their beliefs. But before we fully jump into the case, I want to start us with a little bit of background. We are here because we care about what's going on in our public schools. And we are seeing things that concern us as parents. And that's been a theme, particularly since the COVID shutdowns, when parents really started to see what was going on in the classroom. And then it's continued from there to be seen. And there were many parents standing up and many parents putting together parents groups and doing amazing work to try to get information about what was going on in their schools and push back. But kind of, I think a lot of those parents are wondering, how did we get to this place? And we got to this place for over 100 years. The Supreme Court has said over and over again that parents' rights are fundamental. They're protected by the Constitution, and they include rights to direct their kids' upbringing and education, which then means schooling, healthcare, custody, visitation issues, religious upbringing, decisions about their children's religious upbringing. And so there's been this sort of broad announcement of protection. But then, as clear as the court has been about that issue, the court has not been clear about how to, or the courts really at the lower levels have not been clear about how to deal with the constitutional rights when individual cases came along. So while there's been these great broad principles that parents stand by and know are true, because these are pre-political rights we're talking about. The government doesn't give us the right to parent, but the government protects through the Constitution the right to parent. And that's been over and over announced. But then what's happened in the courts throughout the last 100 years is there's been a few good cases, there's been a lot of silence, and there's been a string of really bad cases. And those bad cases have largely centered on curriculum, what's going on in the public schools. And what built up in the case law was a principle through the courts of really deferring to the school administrators when they're deciding curriculum things. And I think some of that came of the courts not feeling like they could step in to control those kinds of things, but that's become a significant problem. In the 90s and the 2000s, there were a number of cases that I sort of think of as the sex ed cases, as more and more of this of sex ed and things that were a little bit more touching on issues of religion, on issues of politics, on issues that are culturally significant that parents really should be controlling, started coming into the school more and more. And the idea of what was curriculum and what the schools deemed as curriculum just continued to grow. And so parents raised a lot of concerns, and there were a lot of cases in that era about these issues, about the policies, about the lessons that were being taught, about the assemblies. And almost universally, those parents lost their cases, with the courts saying we're going to defer to the schools on what they want to do in terms of curriculum, even when it touches on issues like sex ed. And one of the worst cases out of this string of cases is Fields v. Palmdale, which came out of the Ninth Circuit and was a California, that controls California. And what came out of that was saying the judge actually said that parents lose their rights at the schoolhouse gate. And that is really what built up this idea that parents, when it comes to education, they can choose public school, they can choose private school, they can choose to homeschool. But once they make that choice, they lose their right to control the curriculum or what their kids are exposed to in the public schools. And that has been what we've been living with since then. And it's been a significant problem, especially as it went beyond sex ed to gender ideology, to critical race theory, to other issues that are very anti-American, anti-Christian that have become infused into the curriculum at schools. But that changed. Then came Mahmoud. Mahmoud and Mirabelli, which I'm going to focus in on Mahmoud as promised. And Dean Broyles is going to come in and talk a little bit more about the most recent decision, Mirabelli v. Bonta. But Mahmoud, just so that you understand where it came from, it was a curriculum challenge. And it was a diverse group of parents that challenged the curriculum in their school, specifically books that were being taught to kids as young as kindergarten, that were focused on ideas about sexuality, marriage, and gender that violated the parents' religious beliefs and their intentions for the religious upbringing of their kids. Prime examples included a book where the little girl was called upon to celebrate her uncle's marriage to a man, books that celebrated gay pride parades, a book about accepting a sibling that identified as transgender and came out as transgender, and the kids sort of working through that. And the message in all of these books was that kids as young as kindergarten, too young to tie their own shoes in many cases, are being told that there are more than two genders, that their gender can change, that they are supposed to be embracing these concepts, because if they don't, that's unloving, that's bullying, that's a problem. And the teachers were given specific instructions about what they wanted the kids to get from these lessons, and it included those themes. So the parents were very concerned about this, as I'm sure all of us would be. So they filed this case against their school district, and it went all the way to the U.S. Supreme Court. And there, the court affirmed the constitutional right of those parents to be notified and to be able to opt their children out of this instruction, this public school instruction, because it substantially undermined their religious beliefs and practices, and importantly, what they wanted their religious upbringing of their children to be. I want to sit on that for a minute because that's a huge change. That meant that they blew open the schoolhouse gates. So post Mahmoud, it's no longer the case that parents lose their rights at the schoolhouse gate, or at least it shouldn't be coming from the Supreme Court. The Supreme Court made sure that parents can control their children's religious upbringing even when they choose public schools. And it is important to kind of focus in on that this was a free exercise case. These parents brought specific claims related to their religious objection. So the decision was focused on the religious objection component, and it left unanswered, what do you do? What are the rights of parents who object to curriculum but don't do it on a religious basis? And spoiler alert, Dean's going to talk about how the court handled that most recently. But to stay on Mahmoud, the practical implication is so important for us. We all as parents need to feel empowered by this decision. I'm going to say it again. This decision says you get notice as a parent of what's going on in your classroom, and you get the opportunity to opt out when what's being taught to your kids violates your faith and your intention about their religious upbringing. So parents need to act on this. And it's in that case, it talked a lot about, it was LGBT related. I think that's what we most commonly hear about is the LGBT related curriculum, but it's coming up in other categories and it's not cabined to that. We at ADF have been talking to parents who are concerned about sex ed curriculum because of how graphic it is at young ages, horror and occult curriculum, violent curriculum that they think isn't age appropriate. And so there are many things that parents can be aware of and can be asking for an opt-out. So what do? You get the curriculum from your school, you understand the curriculum, and you look to see if it undermines your religious beliefs. And if it does, you ask for an opt-out. That sounds simple. That is kind of tricky. So there are a lot of us organizations that are trying to help parents with resources, with sample opt-out letters, with advice about how to do these things. I find that you get a certain amount of curriculum through your schools, what's posted online and what's available at back to school, but being in conversation with teachers and with parents, so much is shared through Facebook groups with parents, and you have a right to ask for curriculum and give notice of curriculum that you would be concerned about. There are many schools too, and I think others on this call are going to talk about, that are acting on sort of a don't tell policy because you didn't ask. And so if a parent doesn't raise the concern, they don't tell them about the curriculum. So we're seeing parents be very successful with beginning of the school year letters that say, I want to know if my kid's going to be exposed to curriculum that has this content, and I want an opportunity to opt out. I'm putting you on notice right now that this violates my sincerely held religious beliefs. And so a good opt-out letter includes reference to the beliefs that you that are being undermined by the curriculum, specific materials, as much as specificity as possible, because then you get around any question that they don't know what you're asking about. So as much as you can be specific, that's helpful with the curriculum. And then requesting that prior notice and confirm that your decision is to opt your child out because it violates your religious beliefs. But again, just to underscore, because before we bounce on that, there are many resources available to help. ADF has resources. The other groups here have built out resources, and we're going to try to make all of those available to you afterwards. We're also, I think all of these groups are actively trying to help and empower parents. So if you're having trouble with us, contact us. We're happy to walk through it with you. I think there's going to need to be more litigation on this issue. So certainly if you're being told that you can't opt out, all of us would be interested in hearing that, because it's important that we make sure that sort of the enforcement mechanism of Mahmoud really stands.
Thank you, Kate. I really appreciate that very much. And I can already tell we have several great questions that have come in. So we will make sure that we save those to the end, but very thought-provoking discussion. Kate, one other thing, by the way, this is somewhat tangential, but are you based in Arizona or in DC?
I'm personally based in Seattle, which is a
Okay.
very scary place to be right now. Because Seattle has said out and out, we're not following Mahmoud and we don't care what anyone says. But I used to be based in our Arizona office.
Gotcha. Okay. Well, I'm glad at least that you're not having to stay up until 10 p.m. to chat with us, but we appreciate you coming to us from the war zone of Seattle as well. So thank you very much. So next, I'd like to go ahead and shift over to Dean. Dean, I know you are particularly excited about this case for Mirabelli because while this has kind of taken the rest of the country by storm over the last month, this you are no stranger to this case. In fact, you have been telling our coalitions, the calls that you and I and our other CFC staff are on. You've been talking about Mirabelli for years now. So I am so excited to let you share about this. And Mahmoud is a huge win. Mirabelli is almost as big, maybe bigger, depending on the specific area of law. But these two together are really a 1-2 punch. So go ahead, Dean, take it away.
Yeah, the Mirabelli decision was just that came out just earlier this year is actually late. Well, yeah, earlier this year, just in March 2nd, was fantastic. And it really highlights what the court was starting to say in Mahmoud and extends Mahmoud. And so California, like a lot of other states, has taken the position that minor children in public schools have a right to privacy to somehow secretly socially transition their gender identity at school without their parents' knowledge and consent, unless the student expressly gives the school consent to tell their parents. And so, this sets up an obvious clash between the privacy rights of minor children whose prefrontal cortexes are not fully developed yet, and the rights of parents to know what's happening with their child and to be able to help their child with serious uh, medical and maybe even mental health issues. We'll talk about that in a minute. But the case actually started in my hometown here in Southern California of Escondido in North San Diego County. And two Catholic Christian teachers had asked for religious accommodation to the gender secrets policies. And so the gender secrets policies are fairly broad, but what they were asking for exemption from is they said, we don't want to conceal important information from parents about their child who has gender incongruence or gender dysphoria at school. We don't want to actually lie to parents. We don't want to keep separate files. There's been kind of a two-file system created where there's the file that the parents see with the biological sex of the child and the name the parents gave the child, and then a separate file often with the gender identity of the child and the pronouns they prefer and the bathrooms they want to use and things like that. And they've kept those files from parents and hid those files from parents. It's really criminal in my mind. But these teachers didn't want to keep secrets from parents, and they wanted to be able to tell parents if their child struggled with what we call gender dysphoria or gender incongruence. They didn't want to use the student's self-selected pronouns or names that didn't align with the child's biological sex. So back in 2023, like Jonathan said, we've been talking about this case for a while. It was a fantastic initial ruling on behalf of the teachers at the preliminary injunction stage. And Judge Roger Benitez, who's one of my judicial heroes, issued a great ruling that said the gender secrets policies promoted by the California Department of Education and put in policies in almost all school districts in California create a, quote, trifecta of harms. It harms parents, it harms students, and it harms the teachers. And they had some great testimony from mental health experts. And actually, both mental health experts on both sides, both for the state of California and our side, testified that it's clearly the best practice for parents to be informed and involved when a child is experiencing gender incongruence. For a number of reasons, the parents know the child the best, the parents love the child the best, and the parents are the ones who are likely to get them mental health intervention if the child needs it. So there's some really good facts and evidence that came out in the case. The case uh, went along, and there was a lot of California defended and over litigated the case, and is still doing that to this day, actually. But ultimately, I encouraged the legal team litigating the case to try to get parents involved. And they eventually got parents involved, and a class action was certified that included the class action components included objecting parents and teachers across the state of California who objected to the gender secrets policies. So ultimately, what the case, the rulings came down, and there was a motion for summary judgment last fall. And the court said that the rights of parents to the free exercise of religion and to direct the care, education, and health of their child were violated. And so there's First Amendment rights violated, there's 14th Amendment rights violated of parents. And then the court also found, Judge Benitez found that the teachers' rights were violated. The rights of religious teachers to inform parents and provide parents with accurate information about their child were violated. Okay, so great ruling. And Judge Benitez issued a permanent statewide injunction, which is still mostly in place. We'll kind of highlight that in a minute. But the permanent statewide injunction protected both parent rights and teachers' rights regarding these gender secrets policies. Ultimately, the Ninth Circuit issued a temporary stay, and then the litigants appealed that on an emergency basis to the U.S. Supreme Court. And thank God the U.S. Supreme Court decided to hear the case and issued an opinion on March 2nd, 2026, just a few months ago. And the court did not voted 6-3 in favor of the parents, first of all. But actually, if you read the entire opinion, it probably will turn out on the merits if the case does not get resolved before then as an 8-1 decision with Judge Jackson Ketanji Brown as the outlying dissenter, really. The other two justices said, we'll probably rule for the parents for the parental rights, but we just don't like the emergency quick way this case came to the court. So we expect a really strong ultimate ruling. But they issued this was a per curiam kind of emergency ruling. And usually they're very short rulings. This was a very long ruling where the judges explained their opinion. And they ruled clearly in favor of parental rights. They said, first of all, the First Amendment protects the parental rights to the free exercise of religion. And basically what they said there is we meant what we said in Mahmoud. If you recall what they said in Mahmoud, they said that parents have a First Amendment religious free exercise right to guide the religious development of their children, and that right should not be undermined in public schools. So here's what the court said. Quote, California's policies likely trigger strict scrutiny because they substantially interfere with the rights of parents to guide the religious development of their children. And they cited Mahmoud and the case that Mahmoud relied on, which is a case called Wisconsin versus Yoder. And the court went on to say, indeed, the intrusion on parents' religious rights here, which is uncontested facilitation of a child's gender transition, is greater, hear that, greater than the introduction of LGBTQ storybooks we considered sufficient to trigger strict scrutiny in Mahmoud. So what the court is saying is, hey, in Mahmoud, it was bad. They were exposing kids to things, books that were undermining their parents' religious inculcation that they wanted to teach at home. Here, it's even worse because they're actually transitioning the child behind the parents' back socially at school without the parents' knowledge or consent. So the First Amendment right is violated by gender secrets policies. And then they went on to say, broaden it beyond just religious parents to actually all parents. And the court said here that the 14th Amendment protects the parental right to direct the education and care of their child, which includes the right to protect their mental health. So here's the court said, under long established precedents, parents, not the state, hear that very clearly. It's a repudiation of what Kate was mentioning earlier, the Fields versus Palmdale case that we all had to live with since 2005. But it says, under long established precedents, parents, not the state, have the primary authority with respect to the upbringing and education of children. And they cited a case from a long time ago, early 1900s, actually 100 years ago now, the Pierce versus Society of Sisters. Then they went on to say the rights protected by these precedents includes the right to not be shut out of participation in decisions regarding their children's mental health. Okay. And so because the court basically was saying because gender dysphoria or gender incongruence is a healthcare issue, parents need to know, period. Most of us know that in public schools, you can't give a child a Tylenol or ibuprofen without the parent's consent. Well, here, the school thought it was a great idea to affirm gender identity, to engage in sex rejecting social procedures, to transition this kid to school by using preferred names and pronouns and allowing them to use bathrooms that didn't align with their biological sex, among other things. So, key issue here. Now, if you think about it out loud, if gender dysphoria is a healthcare issue, which I believe it is, and the court says it is, parents need to know. So if parents need to know, somebody needs to tell them. And then we'll talk about that in a minute. But let's talk about some of the implications of the Mirabelli ruling for parents, schools, and teachers in California. First of all, what can parents do? Because some districts, California is very stubborn. California seems to like to think that state law supersedes or trumps federal law or constitutional law, and that's just not the case if you know anything about the U.S. Constitution and the Supremacy Clause. But there's some very reluctant districts in California, probably most of them at this point, are interpreting the court rulings in Mirabelli and Mahmoud to require parents to object before parents need to be notified. In other words, what they're taking the position, kind of a don't ask, don't tell position. In other words, if parents don't object and tell the school that they don't want their child transitioned at school behind their back, then the school can go ahead and transition their child at school behind their back. So we think ultimately that viewpoint on the Supreme Court's ruling is in error and will not last and will not survive strict scrutiny. But right now, while Mirabelli is still being litigated, there's some still unanswered questions. We believe that ultimately the court's going to rule that because parents have a right to know, the school has to tell them whether they ask or not, or whether they consent or affirm or don't affirm. So for the time being, and we've created a resource that's in the resource guide that you'll be provided. I believe it's on the webinar website, and Jonathan can talk about where it is. But one of the resources is a written notice to the school district, superintendent, principals, and teachers demanding that parents immediately be notified within 24 hours if their child expresses any gender incongruence or gender dysphoria at school, including but not limited to requesting use of self-selected pronouns or names, or access to bathrooms or facilities that are inconsistent with their sex. And so we cite to the Mirabelli and Mahmoud decisions in the notice, and we tell school districts, you have to tell us. And if you submit that notice to the school, they should tell you. And if they don't, come talk to us and we'll consider filing a lawsuit because they're violating your constitutional rights. So we're looking actually, as Kate mentioned, for plaintiff parents who may be denied their Mirabelli, we'll call them for now, their Mirabelli notice rights. So there's a great notification that Michael will probably go into a little bit more detail on. But part of the Mirabelli permanent statewide injunction that is still in place reads as follows. It's a notification that schools have to put in all their training they do with students and with children and parents and even teachers when they deal with gender identity issues. It says this is from Judge Benitez's ruling, and it's still in place. And if you go on the CD's website, it's actually on the California Department of Education's website. So this isn't just me making this up. This is actually language from the case that's enforced statewide in California, which is a miracle. Quote, parents and guardians have a federal constitutional right to be informed if their public school student expresses gender incongruence. Teachers and school staff have a federal constitutional right to accurately inform the parent or guardian of their student when the student expresses gender incongruence. So that takes care of the original plaintiffs in the Mirabelli's case, their claim that, hey, we don't want to keep secrets from parents. So if teachers want to tell parents, they have a federal constitutional right to do so. And then it says these federal constitutional rights are superior to any state or local law, state or local regulations, or state or local policies to the contrary. So if your district or district's council is telling you, hey, we have to follow state law over federal law, you can tell them, no, you don't. There's something called the supremacy clause, which I mentioned earlier. So again, we encourage all parents, whether they're religious parents or non-religious parents in California, you have the right to be notified if your child expresses gender identity issues, gender dysphoria, or gender incongruence at school. And we encourage you to find the form and the resources, fill it out, and submit it so that your kid is not transitioned behind your back. There's a lot of really bad stories that come out of some of these cases. One of the parents in the Mirabelli case, actually, a set of parents, had their daughter transition behind their back in public schools, and they didn't find out what was happening with her until she attempted suicide. And then she transferred to another school, and then they tried to transition her behind her parents' back again. So we encourage you to not have that happen to you or your family. And so I want to turn it over to Michael now, who's going to discuss how teachers should request religious accommodations from these gender identity policies in the PRISM training.
Well, perfect. With that transition, you barely even need me to say anything, but I will just chime in there, Dean, because you did bring up very quickly the resources page. So I'm going to just give you a very quick sneak peek. We'll give you the link to all of this a little bit later. I know that I think Sophia is going to be sharing this in the chat if she has not shared it already, but just very quick before Michael gets started. This is the new resource page that we have put together. It is hosted on the CFC website, but if you scroll down here and look, it has resources from our friends at Alliance Defending Freedom, Kate's organization. Great resources here as well from Dean and National Center for Law and Policy, as well as a way to contact him directly. Pacific Justice Institute, multiple things for parents, and then opt-out forms from our friends at Opt Out California. So this is in the chat. We will reshare it again at the end of the chat, and you will also get it if you're listening to this as you're driving. Don't worry, you can go to our website, californiafamily.org/parental rights, and you'll be able to get any of those resources. But don't look at them now. Just wait. You'll have time. You can go to that website anytime. I want to make sure you're listening to Michael as he is sharing with you the next portion. And yeah, we've talked a lot about the parental rights angles, but Michael, I'm excited to have you here. We have gotten more questions, I think, on this issue of PRISM than almost any other issue in the last year or two. So many teachers, even in the chat today, I've started to see people say, I'm a teacher, I'm being forced to teach things I don't want. What do I do? So please tell us what PRISM is and what rights, not just parents, but what rights teachers have to protect their students and themselves.
Yes, absolutely. Thank you, Jonathan. And folks, one of the odd things about how we got to where we're at right now is that this isn't new that parents have a constitutional right. It's also not new that students have a constitutional right at school, and it's also the case in the that staff, teachers particularly, have constitutional rights that they do not check at the doors of the school. That's a case called Tinker versus Des Moines, and that case has been around for a long time. I believe since the 70s, 1970s, that it says that teachers have rights. And just because they are professionals and a teacher, that doesn't mean they don't have constitutional rights. And teachers will especially know, and parents are as well, that California has been pushing this gender secrets policy. I like how Pete frames that. I'm sorry, Dean frames that. They have been pushing this for more than a decade, and laws passed in Sacramento are creating a lot of problems in in some ways, California has gone to war against the federal law and federal constitutional supremacy. We can't allow that. We cannot allow that to happen. And that the importance of these cases that Dean and Kate talked about, it's underscored when teachers and parents stand up and be noticed and be heard. It's really, really important. And so we've been doing this for a long time at Pacific Justice Institute, PJI, and we've been representing folks on the something else that has come up recently, the counseling bill. And that's a case we won't get into, but it's something that has been at play here in California for a long time. So, how did we get to this whole issue with the teacher training? Well, there was an AB 5 in California, Assembly Bill 5, and they titled it LGBTQ plus cultural sensitivity training. So the one thing you will notice is it's not cultural sensitivity. What it is, it's training on how to support the LGBTQ plus agenda. That's what it's for. It doesn't make any bones about that. And many teachers have undergone training that says you can say whatever you want if it is to support someone's LGBTQ position. You cannot say anything, even if you're agreeing with the student or the parent, that runs counter to that. And so California, in their infinite wisdom, as part of AB 5, they rolled out this teacher training program called PRISM. And the PRISM folks were, of course, a dozen woke activist organizations, LGBTQ plus organizations, and the fruit of their labors is just insane. It really is coercive and Orwellian. You name it, you can attach the adjective to that. It really does create big problems for teachers. And I think that for a long time there was this a notion that teachers felt like they couldn't really do anything about this because of California's bullying of teachers and staff, and this whole notion that somehow the parents don't have any rights here. It's really just the school's job to transition your children to you force the teachers to do so as well, to keep secrets from parents. And I tell you, I remember not that long ago, but I remember a time when schools wanted parental involvement. Teachers wanted parental involvement. But now the schools have been setting up in California saying that teachers have to just toe the line, have to toe the line with the states speak, and that's it. And so especially Christian teachers who we greatly respect, that they're there that you're there in the school system. They, for a long time, had nowhere to go. Many times we had to advise teachers in the 10 years and plus coming up to the present, before the present time, that look, you can't interfere with the curriculum. But now we have been able to put together resources, particularly because of Mirabelli and Mahmoud. We have been able to put together resources, and I'll tell you, Dean Broyles at the National Center for Law and Policy put together the makings of a great letter, and he asked Pacific Justice Institute for help, and we've joined in on it. We now also write letters for teachers, and we ask the school districts to exempt them under an accommodation for a sincerely held religious belief. We asked them to exempt these teachers who want to get out of it. So there is power here. We have seen the Title VII, which is the federal law, prohibits discrimination against religious beliefs in employment, and the Fair Employment Housing Act, now called the Civil Rights Act, in California. Teachers have the right to ask for accommodations based on sincerely held religious beliefs. This has always been the case. We now have more resources by cases from the Supreme Court to assist you in getting through this morass that has been created by school staffs, the California Department of Education, and the teachers union. Um, so indeed, in the Mirabelli decision, the Judge Benitez he mentioned that specifically teachers don't forfeit their First Amendment rights when they cross the school threshold. And again, that's from the Tinker v. Des Moines case, the Supreme Court case, and that's something that gives power. So between Title VII, that allows you to ask for an accommodation based on sincerely held religious beliefs, which is your whatever the Christian doctrine that, for instance, forbids you to lie, like the plaintiffs in Mirabelli, or forbids you to give a false information out to students and to keep secrets from the parents. These there we can help you put these together in a letter form and add it to the law and ask these school districts to give space for teachers not to have to go through this. So, in the important thing that we need, that the takeaways from the U.S. Supreme Court's decisions is that parents have the right to know, period. That binds everyone involved in the school system. Parents have the right to know. And secondly, and for you teachers, most importantly, teachers have the right to tell them. They have the right to tell the parents what is going on with respect to their child. And the third thing, and it's been mentioned here before tonight during tonight's presentation, is that these rights are not superseded by state law or policies to the contrary. The bottom line is that once the Supreme Court has ruled on a matter, that becomes a matter of constitutional precedent. And the state of California, notwithstanding their bullying, they do not have the ability to supersede federal law. So we suggest a notification as follows. I'm going to read it to you. Parents and guardians have a federal constitutional right to be informed if their public school student student slash child expresses gender incongruence. Teachers and school staff have a federal constitutional right to accurately inform the parent or guardian of their student when the student expresses gender incongruence. These federal constitutional rights are superior to any state or local laws, state or local regulations, or state or local policies to the contrary. we want you to know that by God's favor, we have been very successful. Between Dean's organization and our organization in sending out these letters, we have been very successful in getting accommodations for the teachers who want their accommodations. For instance, the Brea Olinda Unified School District here in Orange County pulled the California Department of Education's PRISM training for all teachers in the district, not just for Christian churches, Christian teachers. And then earlier this month, a charter school in California reported to National Dean Broyle's organization, and you can get all the information for that on the fact sheet, that they were going to exempt all objecting teachers from having to do the PRISM training. And so even the California Department of Education removed at least two anti-religious portions of the PRISM training that were exposed by the NCLP. And again, we're looking for plaintiff teachers who are denied religious accommodation rights. And just know this, we're not just talking about saying, okay, we're going to send you a letter. If we need to litigate these cases, we are willing to litigate these cases. And what you can do, teachers among us, or tell your teacher friends that they can contact the National Center for Law and Policy or Pacific Justice Institute to ask for help, and we will help you create letters. You don't have to bear this laboring, or sometimes it's intimidating to set forth your religious beliefs in writing in a legal document like this. We're happy to help, and we hope you'll join us as we seek to fight this evil.
Thank you, Michael. I appreciate that very much. So, folks, I don't know if any of the rest of you feel like it's a little bit drinking from a fire hose with all this information. I'm going to go ahead and just show you back one more time. I know that Sophia has already posted one of the links in here, but I want to make sure that you can see at a glance where we are at and what the information is that you are going to be able to look at. If you go to the website, californiafamily.org/parental rights, you can see all these resources that we've been able to put together. There again from Alliance Defending Freedom, from National Center for Law and Policy, down here from Pacific Justice Institute, from Opt Out California. And I forgot to show this to you last time, but we actually added back on also regarding PRISM. We've done, as I mentioned, a lot of reporting on this. So if you go to the website there on californiafamily.org/parental rights, you can get links to just about 8 of the most current articles that we have done on PRISM and on the rights of parents and teachers. So let's switch back over here to the full panel. And I want to go ahead, in the amount of time we have left, to go ahead and swap to some questions. I'm going to try to do these a little bit in order so that Kate, I can make sure that we kind of go chronologically, but I might jump around a little bit here. Some people had some that were slightly combined, but let me go ahead and start off. This is kind of a big question that I think, Kate, you can answer, because I know it's been a key thing for ADF, but it is kind of a bigger picture answer. So Dean or Michael, if you want to chime into any of these as well, feel free. Just also one thing also, don't be offended for any of you who I'm reading your questions. I am not saying names, because I know some of you on here do not want your names recorded for posterity. You might benefit from anonymity. So one individual says, if we're supposed to have a separation of church and state when it comes to education, why are schools allowed to teach a new neo-religion of gender that tells their kids their bodies may not match their minds? This is a belief system akin to a religion that has no basis in scientific fact. So why are teachers allowed to put this into curriculum? And I saw several follow-up versions of this question with people saying, well, why does it have to be a sincerely held religious belief? Why can't it just be purely based in parental rights? Now,
Mhm.
I think the Mirabelli case, correct me if I'm wrong, but I think that was answered a little bit in some of what Dean said. But if you could just answer that, Kate, a little bit, maybe the way that Mirabelli actually is strengthened, Mahmoud.
Yes. So this was the piece that we were worried about when we saw Mahmoud is what do parents do if their objection is just ethical and not a religious based objection? And Mirabelli came in and answered that in sort of a one sentence switch, said this right rises under the 14th Amendment, which is parental rights as well, and applied it there. So coming out of Mirabelli, they've broadened. I think there was also a question in here about does it apply to policies and things sort of beyond curriculum. Mirabelli tried to make clear that Mahmoud applies to curriculum, to parents that have religious beliefs, parents that have ethical beliefs that aren't grounded in religion. It applies to policies, and that this is a broad reading. And right after Mahmoud, we did see some courts try to narrow it. On the question of whether gender ideology is sort of a neo religious, I think on a philosophical level, there's something to that. But constitutionally, we've advocated against that because religions get protected as well. There's sort of the establishment concern, but there's also the free exercise concern. And it doesn't qualify under constitutional terms as a religion. And I think that's a good thing because it shouldn't be an ideology that is protected as a religious belief and it doesn't meet the sort of constitutional parameters.
Yeah, I would just add to that yeah, it is hard to put philosophical things, it make it religious. I mean, there's a lot of indicia that you have to have, and it is a deep philosophical ideology that certainly could rise to religion for some people, but it's hard to pigeonhole things into that. We've tried that. Different arguments have been tried in that area in the past and have failed. But yeah, I would just add to that though that what is happening though that overtly religion is being taught in public schools in the form of there's a case out of Chicago recently regarding mindfulness-based stress reduction, which is Buddhism, right? Being taught in the schools as scientific and not religious when it really was religious. We challenged yoga in public schools years ago, and ironically, we didn't appeal that case because we realized the courts weren't ready for that argument yet. But if Mahmoud had been decided, 15 years ago when we litigated that case, we would have won because parents would have had the right to be notified and opt out because it was religiously undermining for Christian parents to have their kids sitting in the lotus position and chanting Om and worshiping the sun god by the Surya Namaskara, which is a whole yoga routine. So, the great thing about the Mahmoud opt-out notice that we've created, and I know others have created, is that it allows parents to opt out not just of LGBTQ things or controversial sex ed teaching or pornographic stuff, but allows them to opt out of a broader range of things that undermine the religion that you're trying to inculcate in your children at home.
Yeah,
I'll also just add that we've raised surveys that I don't think we've mentioned on this call, but being aware of the mental health surveys that are going on in the classrooms. And so our opt out, and I've seen a lot of others pushing an opt out that includes I want to opt my child out of any mental health related surveys,
Yes.
which is
yeah.
important.
In fact, the California Education Code allows that to opt out of that kind of thing as well. And I just would say, it's sort of use what you have. If you don't need to have a sincerely held religious belief to fall under the fact that the Constitution protects parents to raise their children as they see fit, and but if you have that, use them both. You use both the line of cases that have say, hey, parents have the right to raise their children and to bring them up in their way of thinking, as well as if you have a sincerely held religious belief, which that particularly comes into place, and we'll talk about it maybe a little bit here when we're talking about employee teachers who are wanting to opt out as well.
Well, so let me kick over to that, Michael. And again, any of the three of you can feel free to answer this question. But I'm trying to combine because this is good. We've got over 130 people on the webinar at the moment, which is great. And we've got more people constantly chiming in with questions. So hopefully you can't hear all the ding, 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 ding going through. But let me kind of combine these two questions here. And one person says, after 23 years of teaching, my school told me we had to do the training or can't come back. Charter school at will and non-union. I'm not going to do the training. How do I get the form or letter to submit to the district, and what will be my next steps if I get let go?
I would just say, like Michael said earlier, contact either the National Center for Law and Policy or PJI. We've had 100% success rate in getting charter schools with no contract employees exempted so far, and they can be sued just like anybody else as an employer if they don't accommodate you. And I'd love to sue them if they don't follow the law, honestly.
Yeah, and it's important that the person with that question and anyone else similar, the federal law, Title VII, applies to public school districts in California. We've sued them. I know Dean has, and Kate as well. We've sued school districts and said, "Hey, no, you've got to follow the law. That's the law." So,
Absolutely.
There have been a lot of questions on protection for teachers. So just to expand on that, there is a lot of litigation that has gone on, and there are great cases sort of across the country protecting teachers. And then both Dean and Michael have done a lot of work in state. But yes, teachers have constitutional rights to free speech, to religious freedom that need to be respected, and they have Title VII rights to be accommodated for these things. And so there's a lot of law at play. Some of this is continuing to be litigated out, and we do see school districts make really poor decisions and retaliate against teachers. But we're trying to hold their feet to the fire on that and protect teachers as much as possible.
So I have another teacher-related question. Let me follow up on this. Again, trying to combine a couple of different ones here. This one says, is it only curriculum or does it include processes as well? Some have said it is only applicable to curriculum and are trying to narrow it. For example, one of the bills we have in California, AB 727, and school IDs requiring either the Trevor Project or preferred pronouns or different things like that. Are there any specific limitations that are things right now that are not covered by Mahmoud or Mirabelli that teachers need to be aware of, that it's as much as we would love for this to be a magic wand that would solve every problem at school for these teachers, what are some of the limits, and does it include those processes? Or another one I saw someone say, does it include materials that are approved after the start of the school year? What if you sign a form at the beginning of the year, and then halfway through they have a new supplemental curriculum, or they have a new vendor who comes in, like Planned Parenthood or someone who wants to discuss that? How do you handle those things?
Yeah, it should apply to all of those things, and it should apply to policies. Like we're litigating a case over an overnight policy that they placed a boy in the same bed as a girl, a fifth grader, on an overnight trip. And they said this was policy. So there's some of that being litigated. The question of what are the edges of the right, some of that is being litigated out right now because the court sort of announces these broad principles, but then the courts have to, at the lower level, kind of figure out where the edges of those are. But the thing that we can work with here is the breadth of Mirabelli, and Mirabelli specifically addressed a decision called Bethel out of the Sixth Circuit, where the Sixth Circuit had tried to narrow Mahmoud and say it only applies to specific curriculum and try to really narrow that down. And the Supreme Court, in part, I think that's part of the motivation in the per curiam decision, was to say Bethel was wrong, and this is a much broader right than that is indicating, which tells everybody that it applies to policies, it applies to a lot of these things that are going on at the schools.
Yeah, I want to address that question, but in a different way of like, what can we do that's maybe beyond the case, right? And so with Mahmoud, kind of a vision that I have, because I did some research about 8 years ago on, what's the opt-out rate that starts changing the curriculum. And it only takes about 7 to 8% of a classroom to start opting out of a curriculum, to start changing the curriculum.
To clarify,
So
Dean, that is 7 to 8, not 78%,
not
but
78, 78%, very small percentage. So let's say it's LGBTQ or bad sex ed or whatever, that we don't, there's a lot of bad curriculum in California and other blue states that we'd love to get rid of. Woke curriculum is even beyond LGBTQ. So what's a way that we can think strategically long term? And the idea of I have is not just protecting your child or grandchild in public schools. That's great to protect your kid, but it's also good to protect other kids and love your neighbor, right? And so if we get just a small percentage of parents starting to opt out of some of this garbage in California, it's going to start changing the curriculum and eroding what basically the sewage of bad curriculum coming out of Sacramento. So I think there's a long-term strategy here, not just a litigation strategy or an opt-out strategy for your kid, but there's also a strategy that we could start changing the curriculum both in California and nationwide and start getting back to educating on English and math and reading and writing and the stuff that kids don't know anymore.
And I just would add one quick thing on that issue. Look, the bottom line is these cases, they're not a panacea. They're wonderful cases, and we have rejoiced about these cases. I can't tell you how much we've all, even the three of us talking together, have rejoiced about it. But the way we expand their reach is by filing lawsuits. Unfortunately, it's just the only way we can make this a contagion is that we start getting case precedent that expands this and says, no, the teacher actually does have the right, verbatim about whatever we're talking about here. It's PRISM, it might be other training, and that's something we need to flex our muscle, starting with letters, then, if necessary, litigation, and so on and so forth. It can be done. We have seen success.
let me read a couple more because I know we're a little bit over time, but you guys have had such great questions. I want to make sure that we can get to as many of them as we can. One question, Dean or Michael, specifically based in California, I don't know if you guys have heard, we're getting questions about the Keenan Associates training on how to make LGBTQ students feel safe and included. Is that similar to or the same as the PRISM training?
Yeah, it's similar. It's not the exact same. And I know that both Dean and our and my office have worked at trying to tailor letters for the Keenan training, and we have been successful in that. So, yeah, by all means, give Dean's office, NCLP, and or Pacific Justice Institute, my office, contact, and we're happy to work with you on that.
Yeah, I would just add AB5 itself requires that all training be the same or substantially similar and have the same components that PRISM does. So Keenan training, vector training, there's other trainings we've looked at. They're all bad. And our perspective is if they're 80% as bad as PRISM, they still deserve religious accommodation because PRISM is so indoctrinating and so coercive and so Orwellian that anything close to it needs to be knocked out, or we need to seek religious accommodation for teachers.
All right, let me go through a couple more real quick. Regarding the Trevor Project on the back of school IDs, is there anything, Dean or Michael, specifically at this point that we can do about that, as that is now, they're trying to start printing those new school IDs. They're now requiring that to be something that every student carries with them. Is there any accommodation, or does that fall within Mahmoud or Mirabelli?
Well, I think it could, in as much as it interferes with parental rights, it definitely could fall within those two cases. And we've done a little bit of work. There's somebody in our local, in my area of my office, who we talked to quite a bit about the Trevor Project. So reach out. We're happy to at least answer questions about this ID phenomena.
Yeah, I think it arguably violates parental rights and undermines the right to religiously instruct your child, because if your child calls a Trevor Project number, which is a pro LGBTQ group, your parental rights are going to be undermined if you have a biblical worldview on human sexuality, because Trevor Project's an evil organization. So I think arguments can be made and legal challenges could be brought, but it's going to take some focus, obviously.
All right, a couple more real quick we can blitz through. This one is an interesting one. So I'm a Christian with a biblical worldview. I go to a Calvary Chapel church. I have written a couple of letters to my school district after my challenge of their practices did directly go through the process of challenging a book at the school level. Both times I was framed as anti-LGBTQ. I wrote a response, but how can I basically be more successful on this in the future? So I think this was specifically related to specific books, which sounds like a pretty clear case of Mahmoud. But any thoughts or comments on that? If they're just trying to dismiss you as well, you're not raising a legitimate objection to this. As kind of a follow-up to that, someone pointed out and said, in regards to Mahmoud v. Taylor, when a parent wants to opt their child out of curriculum, does the district have the right to require the parent to state why it violates their religious freedom? So in both of those cases, is there a requirement that either for the book or for the curriculum that a parent has to prove their sincerity of religious beliefs?
No, they just have to state that they have a sincerely held religious belief and that the book undermines it. Some schools, like during COVID with vax mandate cases, they'll try to kind of cross-examine you about your faith and push you on it, but they don't have a right to do that. And if they tried to do that to my client, we'd make a big deal out of it. But as to the issue of the book, I don't know what the context of that is, whether it's just a book in the library or a book being used in the classroom. If it's a book being used in the classroom, certainly a parent could ask under Mahmoud to be notified and or opt out their child out from it. So that would fall under Mahmoud. But if it's just a book in the library, those are different kind of issues that we're talking about tonight.
Mhm. And there is some litigation going on those issues in different parts of the country.
Yep.
Regarding, let's see here, do any of these cases protect teachers who do not want to use opposite sex pronouns, even if the family says it's okay?
I would say yes. And other cases that go along with it. Teachers have their own free speech and free exercise rights. They can't be compelled to use opposite sex pronouns. And there's been a number of circuit level cases on this issue. I don't know, besides Mirabelli, I don't know of one in the Ninth Circuit, but maybe Dean does.
I disagree with what you said. It would be a compelled speech and it would be a violation of their free exercise rights.
Mhm.
But the only thing I would add to that is, there's a slew of bad teacher rights and teacher speech cases too that we're starting to have to overcome, just like we've had to overcome some of these bad parental rights cases. So even though we believe the Constitution protects those rights, there's been some cases that have eroded the rights of teachers that we have to kind of push back on.
Seeing lots of people saying this has been very helpful. Thank you for your information. So very glad that we can help you with all of that. Just as we're just wrapping up here, let me see if I've got one or two more that might be really valuable. Is the cultural sensitivity training accommodation, specifically for PRISM, does this apply only to K through 12, or would this potentially apply to something similar for higher education?
I actually think that freedoms in higher education are more profound for professors under academic freedom, if I'm understanding the question correctly.
Yeah, religious accommodation applies under Title VII and Fair Employment Housing Act across the board, and it would protect, everyone.
All right. Let's see here. In regards to PRISM, my district has given a passive exemption. They acknowledge receipt of my request and that the state has not given direction on the exemption. The district will need to report to the state who took PRISM, and the district will share the exemption request. Have you heard from any movement on the state on how they will direct the districts in those cases?
No, in our letters, we're actually accusing the CDE of leaving local districts and administrators twisting in the wind on this one. After helping create the problem for the last decade and pushing these parental secrets policies, they're now, after Mahmoud and Mirabelli, they've grown strangely silent. And they're yeah, it's not good because they're basically taking the position from AB5 that it's mandatory under state law, and a lot of districts are confused about what they should do. But as I've explained over and over again, and the court said Mirabelli, local and state law does not trump federal or constitutional law.
Yeah.
All right, so I think this might be the last one, and then I'll just kick it to the rest of you if you have any closing comments. But I know we oftentimes have trustees or school board members on the call. And this is from, let's see here, school board trustee. Our legal counsel is consistently telling us to follow state law over federal law when it comes to Title IX because we stand to lose more money from the state than federal money. Is there any help to combat this? Dean is already shaking his head.
Yeah, there's help. I would say it may be a funding issue, but I'd love to see the state, join in a lawsuit that they say, hey, no, well, you can do this, you can follow federal law, but we're not going to. I'd love to see the state do that.
Any other comments on that one, Michael, Dean, or Kate?
No, I would just say that, that's California, Sacramento. I've been there testifying for and against bad bills, and they have this hubris that really they believe that California is like its own nation and its laws are higher than federal law or federal constitutional law, and that kind of trickles down to the districts to where they get afraid and they feel like they have to follow state law over federal law. And every time we've sued them, like in NIFLA versus Becerra, when they tried to coerce speech at pregnancy care centers, they always lose. So
Yep.
they're very stubborn and foolish, and they deserve to be sued. That's my simple analysis there.
Well, Dean, that's maybe a good place to end, and then we'll stop with the questions for now. So thank you to all of you who submitted questions, and we'll let any of you have closing comments. But one of the people, as they heard our answer to that question about trustees, the trustee said, "I'm a lone trustee wanting to follow the Constitution. I need help," and I made sure to refer that person over to the links that we posted above and the contact forms. I just want to encourage all of you who are watching, and I'm sure Dean, Michael, Kate, you would agree with this. The reason why we have the Mahmoud decision is because a group of courageous parents sued and took that case all the way to the Supreme Court. The reason that we have the Mirabelli decision is because a group of courageous teachers sued and took that case all the way to the state court, the district court, and then it ultimately was decided on by the Supreme Court. This is, I think, a really important reminder for all of us that the only way things are going to change is if every one of you watching takes action and speaks up. None of these rights are going to automatically defend themselves. None of these rights or freedoms are self-executing. They all require action on behalf of themselves and on the part of all of us. So I know that one of my favorite quotes from Ronald Reagan is, freedom is never more than one generation away from extinction. And I think you look historically, all the great, amazing, incredible things that we've seen happen over the last several years, these two great decisions, so many other decisions dealing with parental rights or family and children, all of those decisions are wonderful, but they could all slip away if we are not willing to proactively push back and remind people of them and take those next steps to make sure that they actually apply in our individual situations. So I encourage you to go back to that website. I'm going to In case you joined late, I'm going to give it to you one more time. CaliforniaFamily.org/parental rights. If you go right here, there is a ton of information, lots of resources, lots of contact information. CaliforniaFamily.org/parental rights. It is really a blessing for us to be able to put together something like this that will provide not just our information, but as you've heard tonight, the institutional knowledge of these, not just these three individuals, but the great organizations that each of them represent. So Dean and Kate and Michael, any closing comments? Kate, I'll maybe go to you first.
I just want parents to feel empowered by this conversation. I love what Dean said about that it takes 7 to 8% of parents asking to opt out to change curriculum. And we've seen when parents show up in droves and ask for something to be changed, a lot of school districts will change it. And that has generational impact. And for those school districts that don't, it sets them up for litigation. And some of the best things that parents can do is just show up and gather the information, ask for the opt out, calmly get all that information together. And either that ask is enough to make change, or you've got the information to take to one of our organizations and say, help me with this. And then we can force these districts to do the right thing and respect parental rights.
And I would echo, Kate, thank you, California Family Council, for putting this on. I really appreciate it. And I hope, folks, that you're seeing that we are organizations that are joined with a singular purpose, and that's to empower parents and teachers. And we PGI.org for our organization. You can ask for help on that. I'm sure each of the other organizations, ADF, of course, and PLC, are in a similar position. And so we want to answer your questions. You can talk to a lawyer, actually talk to a lawyer and get things done. But we're here for you, man. Go do what's right, and we'll back you to the extent we can.
Yeah, I know it's hard because we're living in a what people call a post-truth, post-Christian culture, and there's sometimes a price to pay for standing up. But um, I've just seen it over and over again. A small, underfunded group of people can often, when they're standing for what's good, true, and beautiful and righteous, can make a huge difference. And so, I think as believers, we need to be thinking about a couple things here. Number one is, first of all, kind of more selfishly, our own family members, our children and grandchildren, and what kind of future are we leaving for them if we don't take a stand now? That's number one. Number two is, we're commanded to not only love God, but to love our neighbors. And so I think a lot of these things that we're resisting are hurting our neighbors. And so out of love for our neighbors, we really need to think, hey, what kind of a nation am I leaving to our neighbors who we claim to love or we're commanded to love? So I'm really motivated here in California. I've been here for 30 years doing this work, and by God's favor and grace, the people on this call and others have made a big difference by just speaking the truth of love and standing firm and living not by lies.
Amen. Well, Kate, Dean, Michael, thank you so much for investing your time and helping to share this information with everybody on the call. For those of you who are with us, I hope that you will take this information back, as I said, to your churches, to your neighborhoods, to your school boards, to your family, your friends, your grandkids, your nephews, nieces, anybody that you know of who is somehow a parent or involved in the educational system. Share this information with them. Of course, you can share the website, californiafamily.org/parental rights. But I encourage you also to share this webinar with people. It will be available on our YouTube channel at youtube.com/California Family Council. And we will be emailing that out to everybody. If any of you have not gone to that website yet, when you go, there's just a quick little sign-up form right at the front where you type in your name, your email, and your zip code, and we'll make sure that we can get you all these resources and keep you informed in the future. But I just want to echo and again close with what everybody said. We are a lot of times, I don't know if any of the rest of you feel like this, but it feels like you read stories of the Old Testament, and I think a lot of people historically felt that America was a shining city on a hill. We were maybe Israel under King David or King Solomon. It was this great bastion of freedom and hope, and we were a light to the rest of the world. And I think in some ways we still are. But at least in California, I don't know about the rest of you, but I resonate a lot more with those stories of the exiled children of Israel living in Babylon. And there are a lot of times where you wonder, okay, Lord, how long are we going to suffer under these difficult conditions? And I think sometimes you look in those stories and you look at Daniel, you look at Shadrach, Meshach, and Abednego, you look at Jonah, you look at so many characters from the Old Testament who were called to bear witness to the truth in difficult situations. And I think for us here in California, that's what God is calling us to do. And thankfully, we have great friends and allies like these three legal organizations who can fight alongside us. But ultimately, I am grateful, as we just celebrated 8 days ago, we serve a risen Savior who's in the world today. And I won't sing the whole hymn, but we do know that because Christ Jesus lives today, we can fight these battles with not out of a sense of fear or despair or desperation, but from a place of victory and hope. So I want to thank our wonderful friends here for joining us. Kate, Michael, Dean, thank you so much for being on the webinar tonight. And for all of you watching at home, thank you for working alongside us at California Family Council to spread this information. Thank you for praying for us. And again, I will shamelessly again reiterate, if you want to make a generous financial contribution to National Center for Law and Policy, to Pacific Justice Institute, to Alliance Defending Freedom, or even to California Family Council, we would be very grateful for your support. Please continue to pray for us and stand alongside us. But folks, God bless you, and we will be back hopefully very soon with another one of these webinars. God bless.